Assalamualaikum warahmatullahi wabarakatuh. Hello everyone, we are from Group 5. In this video, we would like to share our discussion about an interesting and a little bit complicated case. It's about analysis of the juridical accounts payable agreements against Article 1967 of the Civil Code. Case decision of Central Jakarta District number 528. Yes, this is about a concerning evidence and prescription or pembuktian dan DALUARSA. But before we start, let me introduce our team first.
Hello everyone, my name is Atha SAPUTRI.
Hi, I am VIRA AZRA. My student's number is 811-421-253.
Hi everyone, my name is Linda.
Hello, my name is WINDA Maharani Sartono. You can call me Winda.
The debt receiving agreements can cause problems if the in-debt party does not fulfill the obligation that have been determined or the usual so-called breach. From the matter of breach, if the in-debt party has not responsible for the agreement that has been made and the case has been brought to justice. The case may be forfeited within 30 years stipulated in Article 1946 of the Civil Code in connection with the issue expired receivable on May 22, 1968 Carson lent money to Kalim amounting to 15 billion with an interest rate 2.5% per month and 2,000 per day and major on May 22, 1980 building at Pangeran Jakarta number 101 Central Jakarta area is 69 meters. Based on the description of the background that I have described, then several problems will be discussed. First, how is legal certainty for creditors regarding the loan agreement with overdue collateral? Second, what is the basis of legal consideration used by judges in deciding case of the loan agreement with overdue collateral?
I want to explain about concerning evidence this paper. Concerning evidence, according to Juridical, the proof contains logical, conventional, and juridical meanings. In a logical sense, the proof is giving absolute certainty. In the conventional sense, it means certainty but not absolute certainty. In a juridical sense, proof means giving sufficient reason to the judge who examines the case to provide certainty about the truth of the case submitted. Proof has a legal basic, namely Article 283 Requirement for the PN.JKT.PST or 163 Reason in Lands Requirement that whoever says has a right or express an act to uphold his right or to deny the rights of others must prove the existence of that act. The evidence set out in Article 18 and 66 of the Civil Code, Article 164 Reason in Lands Requirement. Article 284 Requirement for the PN.JKT.PST includes letter, witness, scarcity, convention, and oath. The burden of proof. According to Munir Fuadi, the burden of proof is a determination by law about who shall prove a fact that is questioned in court. The proof in civil servants stated that the judge, based on consideration of the result of his observation during the trial process, will determine which party shall prove, and with the truth, it will be the basis for making the final decisions. Matters that need to be proven and not. Matters that need to be proven under Article 163 Reason in Lands Requirement and Article 283 Requirement for the PN.JKT.PST are rights or even that are postulated by litigants. However, not all rights or even are proven. Only rights or even denied by the opposing party. In addition to the things that need to be proven, some things do not need to be proven, namely lawsuits that are recognized by the opposing party, the vision of the judge in advance of the trial, and which are known to the public. Thank you for me. The next presentation will be continued by my partner, VIRA as well.
Expiration, according to Article 1946 of the Civil Code, is a legal means to obtain something or a reason to be realized from an engagement with the passage of a certain time and with the fulfillment of the conditions specific in the Act. Expiration can be obtained when the last day of the required period has elapsed. A case of problem, whether civil or criminal, has an expiration that is regulated in Article 1967 of the Civil Code. Period is divided into two kinds, including first, acquisitive forgery. Acquisitive forgery is past time as a way to obtain ownership rights to objects. This has been regulated in Article 1963 of the Civil Code. Second, extinctive forgery. Extinctive forgery is a person who can be realized from a billing or legal claim that is past 30 years following Article 1967 of the Civil Code.
So now let's talk about the legal certainty for creditors and the decision of the District Court number 538 regarding debt and receivable agreements with overdue collateral. So the legal certainty of the case with the creditor is that this case cannot be continued during the plaintiff's lawsuit due to several proven reasons that this case cannot be followed up. So the first reason is that since the proof agreement was created in 1978, creditors conducted the first automation in 2007, which is 29 years after the agreement. And the second reason is after the plaintiff made the second and third automation in 2007, in 2030, initiators sent the last automation to the new address. The plaintiff offered to submit a guarantee of a building on Jakarta Street and write off all debt made in 1978. In 2014, the plaintiff registered to the Central Jakarta District Court based on a default suit because the defendant had no good faith to make debt payments made in 1978 until 1980. However, this case is considered expiry or prescription following Article 1967 of the Civil Code because it has exceeded 30 years. Therefore, neither the creditor nor the plaintiff can claim the guarantee.
Discussion number 2. The basis of legal consideration used by judges in deciding case regarding agreement debt account receivable with a guarantee that passed the time. Article of number 1967 Civil Code that says all lawsuits, both those of nature and those of an individual nature, deleted because of the passage of time within 30 years. While the person who is pointed to was past that time, no need to show a basic right, and against it cannot be submitted on agile based on bad faith. And the Article of 1320 of the Civil Code says that to have a valid agreement, 4 conditions needs to be fulfilled. The first one, that the agreement of those who commit themselves. Second, the ability to make an engagement. 3, a certain subject matter. And the last one, a cause that is not forbidden. Article of 1313 of the Civil Code says that an agreement is an act in which one or more people commit themselves to one or more people. Article of number 16 paragraph 3 and article number 20 paragraph 1 letter B of law number 4 of 1996 concerning that the right to dependence on land and items related to land. Discussion 2, Part 2. The basis of legal consideration used by judges in deciding cases regarding agreements, debts, account receivable with a guarantee past the time. In court decisions, judges' consideration included: first one is considering that the claimant's lawsuit has expired or passed the deadline. Second, considering that the defendant signed a letter of agreement to borrow the money was asked to be told by his parents. Third, considering that with the claimant's statement The defendants acknowledged the debt to the plaintiff but could not prove. Fourth, considering that if it's true that the parents who ordered it will be responsible if the parents die or their children are supplanted. 5. Considering that the defendant must return the claimant's money because it is a debt of money. And the last one, number 6, is considering that the guarantee of land and the building standing on it must be sold or questioned first. For guarantees promised in the agreement in the form of one building in Prince Jakarta at the price of 9 million rupiah and one piece of evidence of notary deed of buy or right alas number 61 June 23, 1977 land right to building on number 189 at Mangga 2 Selatan at the amount of 3,500,000. The transfer of defendant's right cannot be requested because of the plaintiff is not given a guarantee in the form of a dependent right in accordance with the article of number 16 paragraph 3 of the Dependent's Right Act.
In conclusion, often people have problems in their economy that require them to just borrow. However, many debtors often renege on the agreement or default. In this case, the debt agreement that exceeds the time limit is called an expiration of more than 30 years as regulated in Article 9046 of the Civil Code. This was experienced by Carsono as the plaintiff or creditors who sued Kalim or debtor for a breach of contracts in 1997. The creditor has made a third summons. However, the creditors only reported to the Central Jakarta District Court in 2014. This, of course, is past an expiration date. The legal certainty of the case with the creditor is that this case cannot be continued to win the plaintiff's lawsuit due to several proven reasons that this case cannot be followed up.